many, rare, but the court has taken a look at it. The materials are already in the volumes handed over to your lordships and your ladyship on the last date of hearing. One of the cases is AIR 1951, Supreme Court 332.
Is it here?
Yes, sir, in 1A, volume 1A. This is the yellow bundle handed over last time.
Page
332, and there are, particularly if your lordships will see para 334.
Page 3.
332 इसमें तो नहीं, 1 में नहीं है.
ये वाले
1A.
Sir, 1A, this is the yellow one. 1 is blue, 1A is the yellow paper book handed over last time.
3.
The judgment starts at page 300, handwritten page 300. It is cited as, the citation is AIR 1951, Supreme Court 332. And the relevant paragraph is paragraph 4.
Which is the page of the book?
My lord, the page of the book is 300.
300. Thank you.
If your lordship may turn to the page of the book at paragraph 334, which will appear at page 395.
There 186 is 143.
Yes, sir. I feel bound to say with the utmost humility and for reasons given already that the observations of the majority of the federal court in that case went too far, and in agreement with the learned Attorney General, I am unable to accept them as correct exercise.
Which page? Sorry.
I can't
Sir,
find
page
it.
395. 395. It begins at 300. Page 395. The first column on the left. 14 lines from the foot of the page.
Ji.
I feel bound to say with the utmost humility and for reasons given already that the observations of the majority of the federal court in that case went too far, and in agreement with the learned Attorney General, I am unable to accept them as correct exposition principles relating to the delegation of legislative power. So they cast doubt on a judgment earlier expressed. My lord, in the cases of auction of spectrum licenses, the Supreme Court decided the case in one way, and the matter was then referred to the Supreme Court in an advisory opinion. The citation is reference number 1 of 2012. 10 Supreme Court cases, page 1. The relevant pages are 61 and 65. This is also there in tab 2 of volume 1. This is the yellow bundle, volume 1A, the yellow bundle.
Page 60?
Page 35 of the handwritten page 30.
ये आप पहले भी बता चुके थे.
जी सर. ये judgment से पिछली बार सर indicate किया था कि the materials where your lordship can examine it are here. And 61, if your lordship looks at paragraph 61,
Page कौन सा मालूम सर?
your ladyship, page 99. If your ladyship looks at the 4th line of paragraph 61, for the purpose of the validity of a reference, suffice it to say, dwelling upon an earlier judgment is permissible. And 65, they express same view.
99.
That they are not affecting the outcome of the Liz. While giving this advisory opinion, the outcome of the Liz between the two affected parties is not affected.
So what did they hold regarding after dwelling on it?
They held that that was incorrectly decided.
They said so.
But they said that insofar as that case was concerned, intra parties It will not have an effect on the outcome, but the law they laid down is correctly in the 2G cases.
And Article 143 is paramateria?
My lord, yes, and if your lordship sees paragraph 65, they say, if your lordship will see sideline C, paragraph 65, therefore that the fact that this reference may require us to say something different, therefore the fact that this reference may require us to page 100 of your lordship's and your ladyship's paper book, therefore the fact that this reference may require us to say something different to what has been enunciated in 2G case as a proposition of law cannot strike at the root of the maintainability of the reference. Consequently, we reject the preliminary objection.
पूरा पढ़ लेना वही. Consequently, we reject the preliminary objection and hold that this reference is maintainable, notwithstanding its effect on the ratio of 2G case, as long as the decision in that case, qua the list inter partes, is left unaffected.
Yes. That's why I read it right in the beginning that they caveated it. They said we can express a different view on law. We can do so in an advisory opinion. Intra partes, the outcome of that list will remain unaffected. My lord, in this case, intra partes, the outcome of the list cannot be affected no matter what your lordship say in this case. The man has been, the accused in that
so
case
how
has
is it
been
different from, you see, I mean, if there's a principle settled in a case, then comes another case later on, and we upset the principle or we overrule the principle, that's the normal judicial process. How would this be different from that one?
My lord, what is happening over here in 2G cases is that this is an issue which the Federation at that time thought may affect the spectrum licenses in future cases as well.
So there was a principle that they wanted.
They wanted the principle to be changed.
In a fresh case, the larger bench could
Could have, but they went, instead of waiting for that to happen, they went through a reference and the court said we could do that, and the same thing happened in the 1951 earlier case which I just
Are they in effect saying per incurium?
They are, my lord, saying that, but they are careful to point out that the list between the parties in that case is unaffected.
So per incurium.
But for all other purposes.
So what would be the legal effect of the 2G judgment? Would that be considered as an overruled judgment now?
That judgment would be considered as not expressing the correct position of law for the citizenry at large, except where the cases it had become a past and closed transaction.
Per incurium ही हो रहा है
for all purposes.
Am I not
It's been declared as a per incurium through a reference.
That will be judgment in personam, because it is inter partes,
or in personam.
Remain in personam only.
That was
That particular judgment, yes.
with regard to
For
any contract between
Yes, my lord.
2G.
Yes, your lordship is absolutely right. With regard to that particular contract of
between the
2G,
parties will
that
not
judgment
be
is
changed.
confined to as a judgment in personam,
yes.
becoming a past and closed transaction for the parties in that case, but the law of the land is different.
Correct.
My lord, so this was, I had already referred to your lordship to the Yusuf Patel case. I need not go there. My lord, why your lordship was saying point out what are the other examples, but may I just point out that if we put the forms aside and we look at the substance, your lordships have in a number of cases reopened. In your lordships have in a number of cases reopened your concluded judgments.
No, we just did the other day in 62(1)(f), but that's overruling it specifically.
That's overruling. But
Yeah.
may I point out, my lord, even more specifically, your lordship in the pensionary benefits case, the matter relating to your lordship's pensions had been decided. A review petition against that had been dismissed. The
Can you
registrar,
give us the citation?
my lord, the citation of the judgment referred to is PLD 2013, Supreme Court 829.
This is the original one.
No, this is the judgment, the final judgment in the pensionary case that I have put in. It is tab 3 of volume 3. And it's a long judgment. Without reading, may I just submit before your lordship what was involved. The pensionary benefits had been decided. A review is filed, a review is dismissed. The registrar of this honorable court says this has come to my notice and writes a letter to the Chief Justice. The Chief Justice constitutes a larger bench, and the larger bench affects the outcome of that already decided case where the review has been dismissed by changing that and by declaring that judgment to be per incuria.
So that's a suo motu jurisdiction there.
That's suo motu under
So
184.
then there is a jurisdiction.
No, so what I'm pointing out, my lord, is that your lordships have, in exercise of your suo motu jurisdiction,
That good law?
opened this window. My lord, it has happened in more than one case.
No, is that good law?
My lord, my submission is that under 187, your lordships have the power to do complete justice, but your lordships need a jurisdiction to do that.
Right.
187
You
is not
can't-
the jurisdiction
doesn't-
provision. Now, over here, your lordship is getting the jurisdiction under 186. The window has been opened by your lordships in earlier cases under 184(3). I know, my lord, your lordship was in dissent, my lord, Mr. Justice Mansoor Ali Shah, but where the sacked employees cases came up before this honorable court, there was a review petition and a 184(3) petition. This honorable court, by majority, this,
Citation?
my lord, I'll just give you lordship the citation.
Well, that's where, I mean, very clearly it
Says
says
2022 SCMR 1691 with my lord Mr. Justice Mansoor Ali
if
Shah.
you see in that dissent, there is a reference to a judgment saying that this cannot be done.
My lord, yes.
So 184(3) cannot look at matters.
True, my
if
lord.
Review has been decided.
What I am pointing out to your lordship is that your lordship's dissent apart, there was a review petition. There was no 184(3) before this honorable court. The court dismissed the review petition. The court then opened the window under 184(3). Your lordship said it can't be done. Your lordship provided the same relief under review jurisdiction. Your lordship accepted the review petition, allowed it, granted the relief. So in terms of relief, it was the result was the same.
The mechanism.
Your lordship said the proper way of doing it is, we have a review before us. Let's decide the review. Let's say we made an error. The majority of the bench said, no, we dismiss the review, but we give them relief under 184(3). All that I am pointing out to your lordships is that your lordships have, in order to do complete justice under
If
187,
we applied that test to the instant case, the review could have been dismissed by this court by saying that there's no error floating on the record or this point was not raised. But then the same relief could have been given under 184 or 187
Yes, that's
if
correct.
we applied that test.
But in the dissent, there's a reference to a larger judgment which was not considered by the majority. It's a settled law that you can't, under 184, go into review matter.
relief we can deliver in this case.
my lord,
Indication.
in a presidential reference, your lordship is only answering a question. The question is, was this conviction and sentence in consonance with Article 4 of the Constitution? And if your lordship says yes, that's the end of the matter. Quite often.
That's a lot of things in it, you see. One is to go into the merits to examine this, which is perhaps not permissible. The other is to just look at the process from outside and see whether at all that was done rightly. So,
My lord,
there's just a question on the 2G judgment. What were the grounds for them to open this up?
My lord,
Was there any bias alleged?
No. On merits, the Federation found that the law had been incorrectly
So on
interpreted.
143, they went into the merits of the case.
Went into the merits. They said a president could ask the question if it could arise in future cases, and therefore this question was being asked.
And in this case, the review was decided already by the Supreme Court or no?
My Lord, not that I am aware of.
But this is just a main petition.
In petition, and it's a presidential reference comes in, and the presidential reference is decided.
What the president is achieving from this reference, what he wants to.
My Lord, the vindication of the principle of and the public interest in the fair administration of justice. A vindication.
But in this case, the level of difficulty was just they could have filed a review.
My Lord, in the case before your, in this case,
Very impressed with the Indian judgment.
my Lord, they have been doing it since 1951. So that was the earlier case where they again.
Are you saying that they've been doing it before my Lord was born? Gives it greater gravity?
Sir, in Indian history, that's a tested and tried jurisdiction. My Lord, let me put it this way. The court, when persuaded that justice was not seen to be done, will not stand by forms and formalities, then the court will hold that in this particular case a remedy could be provided. That's why your lordships have done under, my Lord, otherwise under 184(3) jurisdiction.
Are you going to quote any other precedents?
My Lord, two I have cited. There is a third one where an appeal came to this honorable court under 185. And in that appeal, the petitioner who had come to appeal on other grounds, the case was reopened under 184(3) and he was disqualified for life. Your lordships have now overruled that judgment, but virtually 184(3) was exercised.
Which one was that?
My Lord, that's the case of Shaukat Aziz Bhatti versus Iftikhar Mahmood Khan, PLD 2018 Supreme Court. 578.
This is overruled?
No, we've overruled
it in the Samiullah Baloch case.
We've overruled its effect.
Yes.
But you are saying the principle we haven't overruled.
No. The principle that under 184(3) that window was open to exercise that authority.
Where precisely in this judgment it was done?
My Lord, at page 589, paragraph 19.
Can we have the citation again, PLD 2008?
Yes, my Lord. My Lord, it is, the judgment is PLD 2018 Supreme Court 578.
Matter decided and then reopened in 184(3).
This was a matter which came to the Supreme Court under 185. The Peshawar High Court had decided the matter. The respondent before your lordship was not in 184(3).
Right.
The petitioner was not in 184(3). This was reopened against the respondent in 184(3) and the respondent was disqualified for life.
ये बताएं कि you've traveled to the UK and India, you want to travel anywhere else, so that's it.
My Lord, in US, to give your lordship example, that case law is already in the bundle previously given to your lordship.
Parliament can undo the judgment of the Supreme Court, any judgment of the Supreme Court.
My Lord, that would depend if the judgment was if the judgment was on a legislative issue. Parliament does that. Normally, your lordship sees that in income tax ordinances cases, where the judgment, al-Samrez, molasses, many of these judgments have been overruled. Where the Parliament, where the issue involves an interpretation of the Constitution, Parliament may then amend the Constitution. Parliament may at times can now provide another interpretation. That issue is not before your lordship. Your lordship has left that question open, but in the recent judgment, the reasons for which came out yesterday, Parliament has made an attempt, even by sub-constitutional legislation, to have an impact on what the judicial interpretation of 62(1)(f) was.
We didn't touch that.
Your lordship didn't touch the legislation, but I'm showing it, my lord, only as an attempt by the Parliament to do something. My Lord, in the United States...
Can we give any opinion to the President to take this matter to the Parliament?
My Lord, about...
To give opinion to the President to take this matter in the Parliament?
What will the Parliament do, my Lord, in this case? The Parliament cannot say that...
This is the question of what we can do.
No, your Lordships can say that this case, the process by which the finality of the judgment was reached does not square up with Article 4 of the Constitution, and the due process of law was not followed. That's the first question, and that's a question which can be squarely addressed by this Honorable Court.
So, Mr. Makhdoom, I'm all for correcting injustice. That's what we're in the business of, and correcting unjust history, whatever. But the question is, and you've also pointed out that it's a very narrow window that we have. So I just want to understand, if you could just summarize by just telling us what's that threshold that needs to be met to open it, in the sense, yes, conceptually it's agreed that we correct injustice, but then how? I mean, on what basis?
My Lord, may I begin this by saying that in common law, the threshold changes with time.
Right.
Your Lordship have seen in Pinochet in 2000, the threshold which existed in the entire common law history of the United Kingdom underwent a change. In the facts of this case, the threshold...
No, not in this case. I'm just generally saying that if we were to, there's a question that comes in from a president to look at a judgment. So some principles need to be there. We're not looking at the merits of the case. We're not looking at the principles settled. How do we approach this? We're looking at the, as you said, process. What do we really mean by that?
My Lord, that how was the result achieved? Your Lordship had looked at the process in one case, and that has been done in appeal, so that is why I cite it with a bit of trepidation. In the case of Asif Ali Zardari versus the state, this Honorable Court have looked at the process. Your Lordship, see, in substance, the judgment was not overturned in the sense it was set aside and remanded back. So the charges were not quashed. But the very fact that, in the words of this Honorable Court, a bench of the High Court was chasing the case, this created a reasonable...
Can you give the citation?
My Lord, I'll just give Your Lordship the citation. My Lord, this is
Number 1.
PLD 2001, Supreme Court 568.
Yeah, this was the Kotekna SGS matter tried by the High...
जिसमें conviction हुई थी, 3 judges of the High Court in a 3-member bench convicted them. These were cases originating from the Ihtisab jurisdiction. Late Mr. Justice Rashid Aziz, late Mr. Justice Malik Muhammad Qayyum, and the bench refers to Justice Najmul Hasan Kazmi as well, who was involved in certain stages of the process. That's there in the Asif Ali Zardari case. And
it came up in appeal.
It came up in, that's why I'm saying.
The appellate jurisdiction was being exercised.
इसलिए मैंने कहा कि I cited with a bit of trepidation
I don't see
because
the
it's
relevance.
an appellate. All, my Lord, for the principle. The principle laid down by Your Lordships was that where the justices were seen as chasing a particular case.
Where exactly, which page?
My Lord, if Your Lordship takes a look at this case.
Can you just tell us the page number?
F1.
Your Lordship will see page 589 of F1 में है सर, page 589 पे in particular है. उससे पहले 3 pages की discussion है, which will take up a lot of Your Lordship's time.
No, I just want to know the reference. ठीक है.
The findings start at page 587. And the principle laid down again is reasonable apprehension of bias, referring to the fact...
So the narrow window is bias, and this bias must be discovered much later. It cannot be contemporaneous. I mean, if it's there at that time, then this would not happen.
In this particular case,
Must be disclosed later.
in this particular...
Bias is at that time, but the discovery is later.
Your Lordship will recall, before the hearing of the appeal, just before the hearing of the appeal, the Sunday Times published a report pointing out certain conversations. One need not go into it, but this is one of those cases as a result of which the learned judges of the High Court, though no finding of express bias, or bias beyond reasonable doubt was established against them, they ended up resigning. One was a judge of the Supreme Court by the time this
So
case
I'm
was
trying to
decided.
structure this narrow window by saying that bias was one, and the discovery of the bias takes much, is after the
Later.
judgment.
And what your lordship will see in the materials placed before your lordship, and I will, because the materials have now become multi-volume materials, I'll be submitting a written note identifying where exactly things are. Interviews of a judge who was a sitting judge of the Supreme Court at that time. Interviews of,
Who was that?
my lord, Mr. Justice Naseem Hassan Shah.
This case.
Acha, okay, I thought you were still talking about that case.
Interviews of colleague judges and a judge who was the Chief Justice of the Lahore High Court initially.
We don't know
Mr.
when you
Justice-
cross Atlantic and when you don't
No,
cross it.
well, Mr.
It's just
Justice,
back here.
Mr. Justice Aslam Riaz Hussain at that time.
Right.
Interview of Mr. Justice Durab Patel, where he mentions some of these facts.
Okay.
A book authored by Mr. Justice Naseem Hassan Shah, where he points out that the Attorney General and the judge presiding over the trial in the High Court who had delivered a guilty verdict met him in order to arrange more or less fixing of a bench. The book identified by my Lord Mr. Justice Mandu Khail, which showed that a meeting of corps commanders was called and senior officers was called to ensure that a particular outcome was secured. A book by General Faiz Ali Chishti, who points out that how this verdict was secured. So there is, all those materials are on the record of this case, which show that this was a case where a reasonable apprehension of bias in the judges who were hearing the case. The disquiet of the judges themselves, that the Chief Justice of the day sending one of the judges as an emissary to the three-member bench to see that if unanimity could be achieved by reducing the sentence from death to life. And
So one more question, that even if we collect this material and say that there's a bias, is there any other natural justice principle that the person we're alleging this bias or attributing this bias to has to be heard?
no, my lord, that is the principle, because the principle is not that the bias is to be proved beyond reasonable doubt. The reason is that if that is where your lordships lay down the threshold to be, no case alleging bias will ever come to fruition. Your lordships are not protecting a member of the judiciary or running down a member of the judiciary by holding bias.
No, but that will happen.
No, but what your lordship will see.
Suppose if you
my lord,
attribute bias, then you are tarnishing somebody's reputation.
my lord, that is why in Pinochet, every single judge said, we are not alleging bias against Lord Hoffman. Yet he is disqualified on the ground of bias, and yet this judgment is unsafe on account of bias. So that is where the reason is, my lord, that is why over the years the common law has evolved the test which was called the real danger test in Crown.
Well, I don't know why they, this hypothetical observation, but it could have been easily said rather than bias that it may be perceived by the general public that the judge is deciding his own cause. It not necessarily bias, and this perception that justice must not only be done but be seen to be done, as opposed to bias, means that I think it's a state of mind. And here really what they were alleging was, you are a beneficiary, or your wife is, of an organization, that organization was before your lordship, you should have recused yourself, not heard it. So whether there was or was not bias, I don't know why are we using the word bias here.
My lord, because the use of the word bias...
Unless that's the word available.
My lord, that's the word, your lordship has hit the nail on the head, because that's the word available in common law jurisprudence.
There is no other word.
They were in bias had two categories.
Or he was under pressure.
Sorry?
Was he under pressure? This cannot.
My lord, in this particular case, Pinochet is on a much lower level.
Yes.
There is no allegation of him being under any kind of pressure.
He himself admitted that आप पता है हम तो बहुत कमजोर लोग हैं.
Sir, वो तो केस फिर हायर प्लेन पे हो गया ना. That is an even easier case to disagree with. In Pinochet, they all say he was not biased. And your Lordship pointed out to the wife, my Lord, virtually when your Lordship reads through the law report, your Lordship will see the allegations vis-a-vis the wife were virtually dropped. They were not pursued. The allegation pursued was that he was a member and director and chairman of a charity
कोई
which
बात
was
आती ना
controlled.
your own type case.
And they said,
Don't be a judge in your own cause.
and why they were, my lord, looking at it? Because they needed to broaden the category. Till that time, in common law, automatic bias, automatic disqualification only happened when there was a financial or proprietary interest, a pecuniary or
He's saying
proprietary
that as far as this narrow window is concerned, a perception of bias will do the trick.
My lord, yes. A reasonable suspicion of bias.
Suspicion of
A
bias.
reasonable suspicion of bias.
So if while hearing this reference, can we exercise our power under Article 187? Whether any separate petition is required, or we can do in this petition, or even one of the petition, can we convert it into a petition and decide it?
My lord, when hearing a matter, your lordships have already held in the Hisba bill case that whatever your lordships decide in the reference jurisdiction is binding on all the courts in the country. So for all practical purposes, you lay down a binding judgment. And because your lordships have said that, your lordships, when deciding 186, 187 is an enabling provision. It allows your lordship to do complete justice. It does not create a new jurisdiction. When exercising your authority in 186, your lordship will not say that we will look away what would be complete justice or substantial justice in this case. 187 can be brought into service over here under a 186 jurisprudence. Your lordship, my lord, the Chief Justice, your lordship is absolutely right. They didn't have to. The only reason why they did was that automatic bias before this judgment, automatic disqualification before this judgment took place only in the cases of pecuniary or proprietary interest. They said automatic disqualification will also take place where there was some other interest. So that is the test. That if there is another interest.
So according to you, I mean, the outcome of these proceedings, according to you, would be that having considered all this material, we think that this decision had reasonable suspicion of bias, we think, and hence it is what?
My lord, hence it did not square up with Article 4 of the Constitution and the requirements of the due process of law, which is the first question. If your lordships answer that question and do not want to go into the greater controversy of whether the case was itself in substance correctly decided or not, then that is sufficient. Your lordship...
I think these are. Do you have any other case to cite?
My lord, only which two cases which I had pointed out earlier, I will refer your lordship to them. My lord, Mr. Justice Mansoor Ali Shah was keenly interested in what is happening in other jurisdictions. My lord, some materials came to my hand last night. I'll be submitting those later in photocopied form. But if your lordship sees this volume number 1, Volume 1, your lordship will see after the article by Lord Bingham at item number 16, there are 3 books, 17, 18 and 19. One is on miscarriage of justice, the other is on the Criminal Cases Review Commission, and the third is wrongful conviction international perspective. So what is happening in the world over to correct miscarriages of justice? And what is happening is that in England too, they have now created, even if the judgment has attained finality, what they call the Criminal Review Commission, Criminal Law Review Commission, where a reference can be made to it. And that is how, my lord, the convictions of the Birmingham 4 were reopened. Many of these again, as my Lord the Chief Justice mentioned, sometimes the circumstances are so compelling.
They were reopened in appeal or?
My Lord, under this new jurisdiction created through the Criminal Law Review Commission, the Home Secretary made a reference and the Court of Appeal then overturned the earlier convictions. In US, my Lord, in Canada, they have done the same. Your Lordship will find it in these materials. They have done the same in Northern Ireland. They have done the same in a number of jurisdictions. In US,
But they've done it through some statutory.
they have. In US, they do it through the common law jurisdiction. In US, they have
In US, there is no statute.
no statute. What they have done is kept alive the old English jurisprudence, which is now no longer used in England, which was called the writ of coram nobis, which meant the writ to correct errors.
How do you spell that?
CORAMNOBIS.
N-O?
NOBIS.
That is, I
P
think,
for Pakistan.
curative jurisdiction.
B for my Lord Bombay.
Curative.
My Lord, coram nobis to say, yes, if an error has been made, we can cure it. Now, of course, the issue before your Lordship would be that sitting on your own, under 187 you can't reopen the case, but if a case comes to you in the 184.3 or comes under 185 or comes under 186, your Lordship...
But we cannot exercise curative jurisdiction under Article 186.
My Lord,
it is
your
only
Lordship-
a matter which in Supreme Court reports the opinion.
It's not a curative jurisdiction.
Yes.
It's an authority with the court to recognize that it has committed an error.
For instance, can we, now take a very, a practical thing. The judgment under review states that the primarily approvers' evidence was the determining factor. Now, can we, giving in an opinion, say capital punishment or this is insufficient in a murder case to totally rely upon an approver's testimony? I mean, that will be settling a principle of law, skirting the issue of the decision itself. But can we render an opinion? And once rendered, would it be of binding effect on the high courts and other courts?
My Lord, that's one way, but that goes to substance. Your Lordship may do the same thing in process. I'll give you an example of process. Mia Abbas and the two other witnesses were not inclined to give evidence in a particular way, and that has come through contemporaneous materials. That is there on the YouTube. Your Lordship will find it. I have will be placing that disc before your Lordship. A junior of Mr. M. Anwar on the YouTube saying that how he saw what happened between judges and a former chairperson of the Amir Jamaat-e-Islami in that case, and how these convictions were procured, the evidence was procured. Your Lordship will find that in a letter of Mr. Sharifuddin Pirzada, which forms part of Mr. Rafi Raza's book, which I read out last time, where he says that General Iqbal brought it to his attention that the approvers were saying that their testimony was not independent. They were compelled to give this testimony. And he giving an opinion then that in that case the conviction cannot stand. On that opinion, he then pointing out that virtually in so many words that Maulvi Mushtaq Hussain approached General Ziaul Haq, and the Supreme Court then issued us, and Justice Ghulam Safdar Shah made a statement saying this is what has happened. The Supreme Court was then prevailed upon by General Ziaul Haq to issue a statement correcting what Mr. Justice Ghulam Safdar Shah had stated. Now this shows to you that the process was not based on simply what evidence was there, but was vitiated.
So basically you're saying that, I mean, there could be bad judgments and there are wrongly decided judgments of this court. That's not our business. We're not touching those. We are only limited to a judgment where the process is so seriously biased, which is outside the merits of the case. It is the process, it's the way judges were performing. Could we touch those in this jurisdiction? We can't go into the merits of the case, neither can we say it was a bad judgment, it settled wrong law. That's not our problem. It is only the process, and it only relates to the judge.
My lord, where else would you find a case where one of the dissenting judges, Mr. Justice Ghulam Safdar Shah, publicly speaks and says that this approver evidence was, my word, not his, procured? That the Attorney General of the time writes a letter to Mr. Rafi Raza in which he says that he then communicated to Maulvi Mushtaq Hussain, who approached him, that this would result in the conviction being rendered unsafe and being reopened. Maulvi Mushtaq Sahab then, it appears, he doesn't say though it explicitly, apparently spoke to General Ziaul Haq, who sent out the then Attorney General for treatment, and the Supreme Court issued a press statement. You will not find another case, my lords, where another judge who was in the majority says that the judge, the Chief Justice of the High Court, visited him with Mr. Sharifuddin Pirzada and wanted the composition of the bench to be of a particular kind. This squares up with your lordship's jurisprudence in Asif Ali Zardari of a bench chasing a case. He had decided the case. He had no business to fix the benches in the Supreme Court. Naseem Hasan Shah Sahab saying, it's not proper for me to sit, I am an ad hoc judge, but if my Chief Justice so directs...
We noted that.
And
I remember reading, I don't know, it's about the cat.
about
The cat. Was it said by some judge or not?
About the cat being out of the bag?
No. That I won't hang a cat or something like that.
It is, my lord,
who said
it
that?
is attributed to Justice Qaisar Khan. That remark is attributed to Justice Qaisar Khan, who said
Where will I find it?
during the course, my lord, probably in contemporaneous
anecdotal?
newspaper reports it came out somewhere.
And he was not...
I will take a look at the contemporaneous newspaper reports as well, if I can, that you cannot hang a cat on this evidence. Or something to that effect.
So you've heard it.
Yes, my lord. It was widely quoted.
I had heard it, but I don't remember where it was or who said it.
So it was attributed to Qaisar Khan Sahab. And then, my lord, where else would you find that Justice Durab Patel saying that he wanted Justice Wahiduddin Ahmad to remain on the bench, and Justice Naseem Hasan Shah Sahab also saying that Qaisar Khan's tenure could have been, if he had been given an extension, the composition of the bench would have remained the same, and inviting them to participate in the judgment. And then Mr. Justice Naseem Hasan Shah writing in his book that had the composition remained the same, the majority was with Mr. Bhutto. That's no interview, that's his book. So it would have been 5-4 in favor of Mr. Bhutto's acquittal. Durab Patel Sahab also saying in the interview which your lordship will summon from the archives, your lordship will see.
PTV का जो आपने जिक्र किया Durab Patel का, is that before us or not?
Sir, it's not before you. The clips are in YouTube. I have got a clip.
Mr. Raza Rabbani has not filed
My
it.
lord, if he has, I think Mr.
I don't know if anyone has filed it or not. Sorry, Mr. Farooq Naik. He's referring to some interview by Durab Patel.
I have filed clips.
Of this PTV. Okay.
पूरा interview PTV archives में.
We can get the whole interview and file the clips of Mr. Justice Durab Patel.
If you think
Yeah,
that's
we already
sufficient.
filed it. We have already filed it. When my turn will come, we will get
Mr.
it.
Naik, like me, has the clips.
Yeah.
Or if your lordship wants to see the entire interview, that's in PTV archives.
Okay, we'll bear that in mind.
Your lordship will have to summon that. So
Please, continue quickly.
The submission is that
I just want to push you a bit.
Yes, my lord, I
hope you don't mind.
Not at all, my lord. My lord, Mr. Justice Yahya Afridi asked that question. What other materials, my lord? The two other materials which I would request your lordship to look at are the two judgments from the US jurisdiction, the federal court judgments, which I have referred to several times. These are at serial number 13 and 14 of this blue bundle index volume 1. And in both cases, the federal court overturned in a way. Pages 79 to 84 is one, and 85 to 102 is the other. 79, the handwritten page 79, my lord.
Okay.
What jurisdiction was used?
US,
my lord.
No, I mean...
Supreme Court.
Federal court.
No, my lord, Supreme Court.
My lord, in the Supreme Court, the matter went during the wartime, and the appeals of both Hirabashi and Korematsu were turned down by the Supreme Court. After the war hysteria was behind them, they went to to the court, and they said that what had happened to them
So they were decided matters during the wartime.
during
A lower court undid it.
the lower court undid. They exercised the jurisdiction of writ of quorum nobis.
No, the matter didn't go to the Supreme Court.
No, because the state never appealed. The state didn't appeal, my lord, because what was
ये
asked.
तो I think बहुत ही extreme position हो जाएगी.
But sir, why the state didn't appeal is that the president of the day had apologized to the Japanese citizens who had been interned during
We
the war.
understand that, but a lower court undoing a Supreme Court judge.
Yes, they are saying.
And the other one is?
The other one is, my lord, 85 to 102. That again is lower court
ठीक.
undoing that and
ठीक है, we
granting
will read
relief
it. हाँ.
and granting compensation. The overruling by the Supreme Court came much later. The overruling by the Supreme Court has come virtually very, very recently. I'll just give your lordship the year. In the case of Trump versus Hawaii, this is 2017 judgment where the overruling has come in, and the relevant page is page 38.
This same booklet.
Yes, my lord, this is volume 3 and this is tab 11. The citation is
ये आप कौन सी वाली में?
जो आज दी है सर.
अच्छा आज दी. Which one? Page?
Tab 11, the
Tab
last
11.
page of this. I have just filed an excerpt because it's a very long judgment.
Gee,
My lord, the dissents-
what had happened?
The Supreme Court now says the dissent's reference to Korematsu, and the Korematsu citation is there. It was decided in 1944. The dissent's reference to Korematsu, however, affords this case the opportunity to make express what is already obvious. Korematsu was gravely wrong the day it was decided, has been overruled in the court of history, and to be clear, has no place in law under the Constitution.
Is this the same Trump, the President Trump?
Gee, this is the President Trump's
What was
case.
this case about?
My lord, this case was about Mr. Trump making, I think this is insofar as I recall the facts,
Just very briefly.
there was a proclamation issued by the President, and that proclamation had come up before the Supreme Court.
ठीक. Okay.
The Homeland Security's proclamation, this related to
Okay,
some
okay,
of
ठीक
the
है,
countries and immigration restrictions.
जी.
My lord,
Anything
another
else?
important judgment which your lordship may like to take a look at is the last case. It originates from Singapore, and
Map 13.
tab 13. May I say so? This is Mr. Justice Sundaresh Menon, who is now the Chief Justice of the Court of Appeal, which is their Supreme Court. He is, however, deciding this singly, so his title is a Judicial Commissioner. And may I just read out, my lord, your lordship will see the opening paragraph that is there. That settles the principle, and I'll sit down after reading it.
ठीक है,
Paragraph-
we've glanced through it, huh?
Yes, my lord. If your lordship may see paragraph 12 only. Last two lines. The issue in an application for judicial review is not whether the tribunal, the findings of which are the subject of the challenge, has reached a decision that the courts considers is correct. Rather, it is whether it has proceeded correctly, observing the applicable due process requirements. I am on the second link,
ठीक.
and that's all, my lord.
Anything from Islamic jurisprudence?
My lord, on the issue of a person, I've been submitting materials that a person who is interested in the outcome of the case is unfit to be a Qazi and should not be presiding over the case. That is settled law. A fair hearing is settled law in Islamic jurisprudence. I will place the books on record.
Thank you.
Thank you, sir.
For your help, and I must say that you've done a lot of homework on this.
Thank you, sir.
So now, if we can just do a little homekeeping and decide how we're going to proceed on the next date of hearing, because I think it's now 3 o'clock.
So
May
there
I,
are
my lord,
all three
before
booklets. आपकी तीन है ना?
may I before the
Mr.
lordship
Makhdoom,
do
yeah.
that, have offer a personal apology to Mrs. Justice Hilali in photocopying the bundles which were done today overnight. The photocopier made a mistake and photocopied one bundle less. I apologize. That bundle will be placed before Her Ladyship today. But my unconditional apology for that.
So I'll provide mine to her. Gender balance comes first.
Who are the other Micah? Salahuddin Sahab. Salahuddin Sahab, how long will you take?
About 45 minutes to an hour.
Okay. I hope you're traversing ground not already covered. And I'm sure you must have, there must be commonality. So if you can just now excise that portion, because unless you are not supporting him altogether, that will be different. But otherwise, if you can break fresh ground, we'll appreciate. Are you filing anything for us to see, or have you filed already?
I haven't filed yet, sir. I will be filing.
तो आप करें ना आप काफी हमने वक्त दिया था. अच्छा, और कौन है माइकस इसमें आज? आपका स्टेज 2 में आ रहा है.
जावेद खान साहब है.
Khalid Javed Khan.
हाँ, he's not well.
He's not well.
Okay. आई हैं
जी, उनकी written-
अच्छा, उनकी रिटन सबमिशंस आई हुई हैं. ठीक है, तो मेरे ख्याल में हम आप भी तैयार हो जाएं क्रिमिनल के लिए, बिकॉज वी वोंट डिवाइड इट इनटू 2 एंड वी वुड रिक्वेस्ट इफ आपने कोई चीज फाइल की राइटिंग में कर दिए. ओके. एंड मंजूर मलिक साहब ने कुछ फाइल किया है? रिटायर्ड जस्टिस मंजूर मलिक साहब. हाँ, जस्टिस रिटायर्ड मंजूर मलिक साहब ने कुछ किया? अच्छा, तो वो अगर आना चाहें तो वो आ जाएं, या वो फाइल करना चाहें फाइल कर लें, जैसे भी करें. ठीक है, तो क्या करें?
Supplied the documents which have been given to the court. I'm the complainant. I must be given relevant documents so that I can answer. And I can.
We will ensure that Mr. Makhdoom Ali Khan is further spends money.
My lord, it will
Can
be
you
done.
please provide a
Yes, sir.
set to
the
Mr.
complete
Kasuri
set,
as well?
The complete set which has been
he's-
given to this honorable court.
I think
will be
आपका भी
given.
काम आसान होगा. He's very diligently put together all the case law. He's a micus in the case. So and these cases that he cited, many of them are not available in book form here. So can you do
All the volumes will be given to him.
ठीक.
It will be photocopied and given to him.
अच्छा, तो अब आप अपना राब्ता डायरेक्ट कर लीजिएगा मखदूम साहब से. अगर उन्हें 2 दिन में नहीं दिया, आप उनको फोन करके कह दीजिएगा. He will honor it. He will honor it. Rest assured. अच्छा, अच्छा, तो आप लेंगे about half an hour, 45 minutes. अच्छा, how long will अच्छा, खालिद जावेद खान साहब ने फाइल कर दिया कुछ, एंड आप कितना लेंगे, या आप कुछ नहीं कहना चाहते हैं? राइटिंग में दे दिया आपने? अच्छा, ओके, दैट्स गुड. रज़ा रायबानी साहब, आप कितना लेंगे वक्त?
About at least 2.5 hours.
Because if you, the only thing is, we would love to hear this endlessly, but please be aware that my lord has very few days left, so at least if the hearing is concluded, the judgments can come later also. But and we are so if you can supplement your things in writing if you want to do that.
My lord, I've already done that. I haven't submitted it, but I have my synopsis ready. And out of that, I'll only be picking up 2 to 3 questions which your lordship had put in the order of the 12th. And I will take those up. The others I will...
Otherwise, what will happen is reconstitution of the bench, and you know that.
I know.
Means the case will probably never get heard.
I'll try and be as short as...
So, no, we don't want to push you, but you are aware of this.
I'm aware of it.
जी, ठीक है.
Sir, I'll
Zahid साहब, आप कितना लेंगे?
Sir, I'll take,
Half an hour.
I represent Mr. Bilawal Bhutto Zardari.
जी.
I'll take about 1 hour, my lord, at least 1 hour.
Somebody was
नहीं, मगर ये चीजें
representing
just bear in mind.
जी, जी, मैं repeat नहीं करूंगा, sir. I will not repeat.
No, I'm just, we want to cut short, but then reconstitution means, if it ever happens even.
तो आप मैं समझता हूँ क्या
बड़ी मुश्किल से हमने यहाँ तक लाया इसको.
एमाइकस के बाद अगर आप हमें दे दें, क्या कहते हैं, तो
नहीं, देखें, एमाइकस का फायदा होगा. एमाइकस के बाद तो नेचुरली आप ही आएंगे ना फौरन.
एमाइकस के बाद उसके बाद
सजू साहब, आप खुद बहस करेंगे या आपने कोई वकील किया है? Because नहीं, just one word. No, it's enough.
I'll be talking about the actual case because I have seen...
ठीक है. नहीं, हम सिर्फ पूछ रहे हैं कि अगर आप वकील करना चाहें, आप कर सकते हैं.
सर मेरी इल्तिजा होगी एमाइकस के बाद आप मुझे इजाजत दे दें, फिर रजा रब्बानी साहब को दे
He
दें।
will have the last word.
जी नहीं, रजा रब्बानी साहब को दे दें और फिर क्या कहते हैं?
Yeah, that's how we proceed.
जाहिद साहब भी, जाहिद साहब को-
Yeah, we'll finish everything because amicus
जी, जी।
are supposed to be neutral.
ठीक।
Naturally, you and Kasuri Saab, because it's your case, so he has the right to say
ठीक,
the
वो
have the
आखिर
last
उनको दे दीजिए।
word after he hears what you say.
आफ्टर क्या कहते हैं अपने
ठीक।
सलाउद्दीन साहब के बाद मुझे चांस दे दीजिए, फिर
जब आप
जाहिद
डेट
साहब-
पे एग्री कर लें,
जी सर, डेट आप जो हुक्म करें।
नेक्स्ट वीक में
जी हाँ, जो हुक्म करें।
मंडे को रख लें।
मंडे को रख लीजिए।
Do you need to come? If you are available, please do. Some queries come up.
ट्यूसडे को रख लें, ट्यूसडे को रख लें, that would be better because we all come from Karachi.
Tuesday would be better.
Tuesday would be better, sir.
तो किसी को तो मंडे को
Javed Khan has sent a request for 28th, but that's up to your lordship.
मंडे को हम करते हैं। मंडे को आए ना, आप संडे को आ जाए कराची से।
ठीक है सर, मंडे को कर लीजिए। ठीक है। We'll be here, sir. We will be here on Sunday.
Otherwise, we'll report you to whoever we have to report you to.
वही तो कहती है कि संडे को भी तुम चले जाती हो।
So, bring her along. Good weather in Islamabad.
आपका मुकम्मल इख्तियार नहीं है।
बिल्कुल सर, किसका है? किसी का भी नहीं है।
मैं आपको पूछना चाहता हूँ।
जी अच्छा।
Khalid Javed Khan will be coming, or he just submitted something in
My
writing?
lord, he told me that.
Does he want to be heard, or he just said, "Okay, I filed
My
whatever I
lord,
had to
he
file"?
said that if this case is fixed on the 22nd or the 28th, he would be here and also make.
Monday है।
28th is Wednesday.
नहीं, वो पता नहीं हम फिर कैसे चलेंगे। If someone is not available, we can maybe hear them and then they can come.
Monday
ठीक है, but चलें तो फिर मंडे को हम करते हैं 11:30.
Thank you, my lord.
मंडे को, हाँ
हाँ पता है।
नहीं मंडे को तो कोई नहीं है बेंच, कोई बेंच तो ट्यूसडे को कोई बेंच है। ठीक है, we try to do as unless there are other benches, so we want to finish it as soon as early. By all means, you can give submissions in writing later.
Yes, my lord.
तो